Before we start today, I'd like to acknowledge that I'm hosting this webinar from the lands of the Gadigal people of the Eora Nation, and I also acknowledge the traditional owners of the various lands on which you work on today, and the Aboriginal and Torres Strait Islander people participating in the webinar. Welcome, my name's Erica Taylor. I'm the Director of Learning and Development here at Experts Direct. And at Experts Direct, we source expert witnesses for litigation. We've worked on many complex matters and matters that involve issues that are often too complex to be resolved by a court alone. And expert evidence is oftentimes necessary to understand the complex issues in a litigated case. To properly understand complex issues and address them, it's essential to have the correct expert. It's my pleasure to host today's webinar, The Future of Construction Disputes in the Asia Pacific. We're joined today by a panel highly experienced in the complexities of construction disputes and well informed of the critical role expert witnesses play. Our speakers today are, I apologise, Simon Bellis. Simon is a partner at Jones Day in their Global Disputes Division, and he's an international disputes authority whose practice is focused on large-scale construction projects, especially in the energy, resources and infrastructure sectors. We're also joined by John Donnelly. John joined the DGA Group in mid-2019, having previously been the National Director for a global construction contract consultancy. John is dual qualified with both technical and legal disciplines as a chartered quantity surveyor and having completed a postgraduate diploma in law. Ken Hickman. Ken is also a partner at Jones Day in their Global Disputes Group, and Ken's practice is focused on large-scale construction, infrastructure, mining, energy and transport projects. And we're also joined by SweeIm Tan. Swee is a chartered arbitrator and an international arbitrator member of 39 Essex chambers based in their Kuala Lumpur office. Swee's focus is on construction, infrastructure and energy sectors with extensive experience ranging from the early procurement strategy stage right through to dispute resolution. So while all of our panelists play different roles in the disputes process, they all seek to assist clients to resolve construction claims and disputes effectively according to their objectives and priorities. And so today our panel will be discussing the use of integrated international teams in construction arbitration, the importance of ensuring expert witnesses are aligned early in the dispute resolution process, the procedural complexities of construction arbitration in a post-COVID world, and we'll hear from Swee an arbitrator's perspective on the future of construction disputes. So to kick off, we'll start with you, Simon. Over the years, you've spoken to my colleagues about some of the trends you've been observing in the area of construction disputes. So could you please kick off the discussion with a few observations on those trends?
Absolutely, Erica, and thanks very much to Experts Direct and my friends John, Swee and Ken for the opportunity to be a part of the discussion. When thinking about trends in major construction dispute resolution, we can't overlook the impacts of the pandemic. In terms of the industry generally, from a global and cross-sector perspective, construction continues to be strong. Indeed, it's both the backbone of many national economies, but also the backbone of the economic recovery that's been necessary since COVID. And particularly here on the east coast of Australia, but around the world, we've seen major public infrastructure spending. It hasn't been achieved without a lot of challenges that continue, for example, with labour shortages, increasing costs and supply chain disruptions that we've heard much about. There's been a need for accelerated innovations in terms of the use of technology and the industrialisation of the industry, the increased use of modularisation with embedded digital technology and a resultant shift towards blue-collar workforces. Other relevant factors that the industry is dealing with, of course, relate to the Ukraine war, energy shortages that we're seeing here and in other places in the world, and of course the energy transition. A few years ago, we saw the prices for LNG drop, with the impact being a cancellation of lots of projects causing disputes. And now with prices having bounced back, the question is what impact that will have on projects, particularly where we are seeing an energy transition. We're certainly talking to clients about decommissioning of their oil and gas facilities, but also a greater prevalence of renewables projects and disputes on those projects, which have their own unique challenges. Across the board, projects continue to grow in size. They're not getting any smaller. They continue to be inherently risky. And there does seem to be a continued increase in the internationalization of various markets, where you have international contractors going further afield to expand their market share. We continue to see a failure to learn from mistakes, or at least the repeating of various mistakes on major projects, which cause the continued problems with cost and time blowouts, and insolvency continues to be a thorn in the side of the industry. There was a report on the ABC last night on that in particular, and whilst the industry accounts for about 10% of the GDP for Australia, it accounts for 1 in 4 of all insolvencies, which is an unfortunate overrepresentation. All of this means that there continues to be very big, ugly disputes on construction projects. And I can say that clients are becoming quite weary of those major disputes, and we are getting pushback on that. They're asking us to look for better ways to resolve disputes, new ideas and alternatives. They're asking us to consider how we can streamline disputes and come up with cost savings during that disputes phase. There is some discussion, but not enough, about the structural change that is required to fix the problem more fundamentally, and it's more about lessening the burden of the problem when it arises. Some of the positive developments is a growing appetite to consider adjustments to the risk transfer on projects and to adjust standard contractual terms. There's clearly a greater openness to talk about the possibility of relationship contracting, where there could be a sharing of risks and rewards on projects. And there does appear to be an uptake, at least in some sectors, to apply dispute boards for real-time dispute resolution on projects, and they can work very well. Those are the sorts of positive developments that can actually avoid or minimise disputes. That said, as I said, the big and ugly disputes continue to percolate through, and they end up in international arbitration more often than not. Some of the developments and improvements that we're seeing there are a willingness to talk about how we should structure the pleadings and evidence. For example, the greater application of memorials. I personally think that there are significant benefits to the use of memorials in many cases, and how you structure your pleadings and evidence can also present various strategic advantages for clients. Document review and discovery continues to be the bane of most clients, and there's a desire to limit the scope of discovery and also increase the use of artificial intelligence and the computerization of those reviews. Perhaps most relevant for this discussion is the better application of experts in the dispute resolution process, and I suspect that the panel we'll talk a bit about joint reports and hot tubbing for experts. Defects is perhaps the bane of many arbitrators and judges. The need to go through a schedule of many hundreds of defects on any major project, or sometimes thousands, brings about questions as to whether or not it's better dealt with by way of sampling, and indeed whether or not some of the questions on defects ought be referred out to referees. With the panel, with the rise of COVID, we've obviously seen a proliferation of trials by way of electronic hearings, which has been a significant development, and I think in most cases the sky has not fallen in, and we have been able to continue, whether that be by way of an entire huge hearing being done electronically, or whether it's partially done electronically, where you have some participants in person and some participants dialing in. We have been able to manage that process and to get through. In the discussion of any trends regarding dispute resolution, particularly international arbitration on major construction disputes, there's always a question as to what is the appropriate seat. And for this region, at least, Singapore continues to dominate. It is obviously the biggest jurisdiction for arbitrations in this region, and this year has tied with London as equal first preferred jurisdiction globally. It's overtaken Hong Kong in terms of that role, and perhaps that's been something that's been ongoing for some time, but perhaps has been accelerated by the role of China in Hong Kong, at least by way of public perception. Australia is obviously continuing to participate very meaningfully in international arbitration, not so much as a seat of arbitration, but in terms of trained professionals by way of lawyers and experts and others and arbitrators participating in international arbitration. We've been talking to clients more and more, perhaps because of their weariness to large-scale disputes, about bespoke arbitration clauses. In our view, there is a real untapped opportunity to not just accepting the standard form arbitration clauses that are put forward by the UNCITRAL rules or the various institutions, and some greater thoughtfulness can be put into what an arbitration clause actually provides, and you can have some real procedural and strategic advantage by doing that. The other thing that we've been talking to clients about is expedited arbitration rules. In some circumstances, it may well be preferable for some of the luxuries of large-scale arbitration to be compromised in order to have an expedited outcome. And many of the major institutions, including SEAC, have recently put out new versions of their expedited arbitration rules. But there continues to be other challenges for international arbitration, and in the court of public perception, there continues to be some, at least perceived, room for improvement. Some of the areas there where arbitration is being criticised is around the fact that awards are not published and that there's no appeal rights, and that leads to a perception of arbitration being high risk in circumstances where you don't get the outcome that you want, or the arbitrator doesn't perform to the level that one might expect, and that there's a lack of accountability in terms of the quality of awards, and also a lack of jurisprudence that is being developed in arbitration. In arbitration, joinder can be problematic. There are challenges around summary judgment, and some perceive there to be an issue with procedural discipline, that the idea that if you're in the courts, you would be less likely to miss deadlines than if you were an arbitration, because arbitrators can have a fear of there being a challenge on the basis of a lack of procedural fairness. So there can be a little bit more room to move in terms of procedure. Out of all of these things, we have seen the emergence of international commercial courts. For example, the Singapore International Commercial Court, which is somewhat of a hybrid between arbitration and the court system. And whilst that's been around for 7 or 8 years, it is only just slowly gaining traction, and it will be interesting to see how that institution plays out going forward. I'll be particularly interested in SweeIm's views on some of the things that I've mentioned in terms of the challenges for arbitration going forward. But that's just a basic overview of some of the trends that we're seeing in construction and construction disputes.
Thanks, Simon. It sounds like what was already a complex area of law and dispute resolution has become much more complex with the advent of COVID and the ramifications of the pandemic. So, John, Simon mentioned the need for experts to be aligned in proceedings by way of joint reports, hot tubbing, etc. Based on your recent experience, how can that be achieved, and does it become more difficult when matters are conducted by way of electronic hearings?
Yes, there does seem to be a more of a trend, definitely, for getting the experts together at as early a stage as possible, and that I think is recommended as well, rather than both producing reports in isolation from each other. It's always a good idea, and is, in my experience, frequently more recently directed by the courts or by the arbitrator, for the experts to get together as early as possible in the proceedings, and to discuss issues such as the approach that you might be taking, and also the documents that might be required for your report. And it is obviously sensible to do that, and agree perhaps on the methodology that you might be taking for a quantum issue. So say for example, as a simple example, it might be that you're looking to value variations on a project, and perhaps the appropriate method is to refer to the schedule of rates in the contract, so that the variations are being valued on a value approach basis by reference to the schedule of rates, as opposed to by reference to the actual costs. And those sorts of approaches could be agreed in advance between two experts, so that there is less time being wasted, if you like. It becomes more efficient in terms of the approach, and the documentation, agreeing on the documentation that would be required to support that approach for valuing the variations. So that's one sort of example, I suppose, of how it might become more efficient through that process of early joint reports. Also, things like sampling of the data is also another example of the experts coming together early. And one of the benefits, again, for making it more streamlined, it might be that, say, we were looking at valuing or assessing the delay costs in a dispute, we might, rather than sort of going through all of the time-related preliminaries for the entire, every month of the entire project, it might be that we agree to take a sample, a relevant sample month, or perhaps look at a period of 3 months of the time-related preliminaries and analyze those and come up with a percentage. And by taking a 3-month time period, you'd be allowing for certain anomalies, for accruals and liabilities that might otherwise cause a problem with the outcome of the actual delay costs. But you're narrowing things down to a period of time, and you're both agreeing on that in advance. And then obviously your data set will also be reduced, so the relevant information that you'd be required to sort of verify those costs, such as invoices. You could agree on the fact that you might need to reference purchase orders, invoices, and go right through to proof of payment and evidence that sort of process trail. And so all that can be agreed in advance. It would make it a lot more, makes it a lot more efficient, and you're narrowing down and coming up with a common set of data between the two parties, rather than working in isolation. And we've all seen the sorts of issues that can cause if you go against the grain and don't take that sort of approach. And I think in particular, we've seen it with the various delay experts, maybe having the same question being asked, but coming up with two different answers, purely because different methodologies may have been used by the two separate experts. So agreeing on those approaches is obviously a cost-effective way, and methods such as agreeing on sample sizes and techniques is also very, very helpful. And obviously the sampling would be dictated, I suppose, by the size and the value and the complexity of the dispute in question. In terms of having the electronic hearings, yeah, I suppose the remote hearings were sort of forced upon us, weren't they, through all of the pandemic, and it has, been realised how efficient they can be and how well they can work when that sort of technology is sort of imposed upon us. And yeah, we certainly, in our last expert witness matter, we certainly had were very complimentary, if we like, about the electronic remote hearing process, the particular document management system that was used in that matter. Our most recent matter was called EPIQ, EPIQ, and that seemed to be very efficient. So on the second screen, if you like, any documents that were referred to in our expert report could very efficiently be brought up on the screen, and it was almost instantly referenced and referred to. And so it was a very streamlined process and seemed to work very well. So that particular method of remote hearings through improved technology was certainly very, very efficient. So yeah, they're some examples, I suppose, of how that early reports can benefit and streamline the process.
Yes, I think you've really highlighted the importance of experts working together collaboratively and being aligned so that efficiencies are gained in proceedings. And I think that also maybe goes to Simon's point of parties becoming weary of the dispute process, and where experts can work together to bring those efficiencies that can only benefit everyone involved. So Ken, just picking up on some of the issues raised by John and Simon, what are some of the things that you've seen in your practice recently?
Thanks, Erica. To each of the presenters and to those attending, thank you for coming along. To pick up on John's point first, and Simon touched on this as well, the quantification of loss arising from or as a result of a sort of a COVID-related issue, it's a very difficult exercise because we're dealing with a lot of novel impacts more in the nature of a disruption. And quantifying that, of course, requires pretty diligent record keeping. Is by no means a straightforward process of proving damage. So, one thing that we're saying to our clients is to get people like John engaged and retained early to catch and record things in real time. And a failure to do that leaves you potentially with a sort of swathe of loss that risks only being able to be put at a later time in a global manner. So I think that's the first point, just to pick up on what John was touching on. In relation to the broader trends, there's a great deal that can be practically done by both courts and tribunals to tailor formal dispute resolution processes or aspects of those processes to deliver a more efficient and time cost-effective determination of high-value, complex construction disputes. And experts are a major feature of every dispute. And the complexity and the sort of business integrated nature of those disputes means that in most cases, we're not just talking about time and cost, we're talking about a range of intermingling technical experts, accounting and financial experts, project management, BIM experts, modularization, labour, safety. The list goes on, and it can be extremely time and cost intensive. So aligning experts, as John mentioned, is critical on the questions to be answered, the methodologies to be adopted, and for example, including sampling. But a common practical roadblock to this outcome is the timely and mutual delivery of relevant documents to both experts at roughly the same time in the proceeding. And where this has been a challenge, and it might be owing to poor record keeping, document management issues, disorganization generally, or strategy, we've seen with quite good effect tailored orders which compel production of relevant documents to experts at the same time. So, for example, an order that within 7 days of any document being briefed by one party to their expert, the document must be notified to, served on the other side, and identified as a document that has been brought to the attention of a particular expert. That could be used in conjunction with a guillotine date and the production of documents to experts generally, but that's a step that, for obvious reasons, some tribunals might be loath to make. But it protects, an order of that nature protects the parties against documents not being produced in disclosure for whatever reason, either because they haven't been specifically requested or they've just been overlooked, but then considered by the other party to be sufficiently relevant to provide to the expert to consider. So that's the sort of practical step that can be taken to put the parties on equal footing early on. It facilitates early constructive engagement between both experts. A further trend is the use of tribunal or court-appointed experts and court-appointed referees. So appointed experts might be retained to assist the court in making sense of the parties' respective expert evidence, or in some cases, the order might in fact obviate the need for any party-appointed experts at all. The precise role that a court or tribunal-appointed expert might take depends on the nature of the dispute, the preferences and sort of submissions of parties, their conduct, and the decision makers' preferences, so a range of factors. But particularly in the case of complex technical or usually quantum-related disputes, we've seen courts use their referral powers to appoint referees to consider the evidence and report back to the court with findings or recommendations that can then be adopted by the decision maker. Courts are not usually the beneficiaries of increased funding and resources, and their time is becoming very limited. And so for complex commercial construction disputes, we see this as an increasingly used strategy and approach by the court. There are occasions, of course, where parties will and will not be happy with tribunal-appointed experts or court-appointed referees. In the case of tribunal-appointed experts, they can, in some cases, have the opposite effect by making the process more complicated, less certain, and more costly. A referral to a referee can put parties offside, where particular thought is given years in advance to the mandated dispute resolution forum, and that forum refers the sort of substantive decision-making process externally. That can take parties by surprise, but it's a development that is here to stay, and we see it increasingly being used in court. A recent Western Australian Supreme Court decision involved a judge savaging the parties for the nature of their evidence and strongly suggesting that the case would have been one that would have been appropriate for determination by a referee. So that development is increasing. It's here to stay. On all of these matters, though, I guess it's being forewarned is being forearmed, and parties should be alert to these increasing trends so that they're not caught off guard. On that note, I can pass back to you, Erica.
Thanks, Ken. I think your point about early constructive engagement with experts and issues around making sure documents are delivered in a timely fashion is a really important one, essential if you're going to have the experts be able to perform their role correctly. And I think you've also highlighted that given the many different types of experts you could have involved in just one matter, when selecting experts, it's really important to make sure that the questions you're asking of them are in the scope of their specific expertise. So Swee, we've heard from Simon, John and Ken regarding some of the issues that they're seeing in disputes at the moment. Does this accord with your experience? And in terms of your role as an arbitrator, what guidance can you offer experts in assisting courts and arbitrators in deciding disputes?
Thank you very much, Erica, and thank you, experts Derek and Simon and Ken, for having me on board here. One of the things that's changed is the fact that all of you are sitting there in Melbourne and Sydney. I'm based in Kuala Lumpur, but speaking to you from the United States. So that's one of the things that I think that has actually been a trend that we are going to see much more of, and it's a good thing. I'll start with the fact that in the last 3 years, our lives have all been upended, and everything has changed so much, but yet so little has changed, as we have seen now as COVID tends to recede, and it tends to recede from people's minds and people's consciousness. So we are back to where we were insofar as there are many construction projects that Simon was talking about. With the sort of recessions and inflation that we're talking about, these are now actually the engines of growth in pretty much every country. So the way I see it is that we're still going to be seeing a lot of construction and disputes, if not more of them. And we still have this ultimate goal, which is that if any party goes to arbitration or dispute, they're looking for a result, and a result that can stick, a result that can be converted into cash wherever they may be. So they look to people like myself as a tribunal to be able to deliver that. So it's a simple objective, but I think what we have seen, and from everything that everybody has been talking about, is that that journey remains complicated. If anything, it's getting even more complicated. So let me go back to some of the things that we were talking about, and some of the things that Simon was talking about as to how to sort of narrow the disputes going forward, how to get early engagement between the parties to break log jams as we go along, rather than leaving it to the end and the old kitchen sink approach. I agree wholly, but this is something that we've been preaching for the last 30 odd years. Well, certainly in my sort of professional lifetime. But my question really is, outside of Australia and outside of some of your large projects, is that really gaining traction? I have been seeing in the last couple of years, the sort of sense of oneness that was brought about by early pandemic and the early shock of it. And everybody was sort of, oh, we got all in this together, we've got to work together. You know what? I don't see that really going forward. If anything, there's now some sense of desperation in a lot of parties, whereby they've been hit so badly that they really need to try and sort of dig themselves out of the hole. And in some ways, the disputes are getting worse in that sense, So I think that we are still in that kind of situation. And when we talk about Asia Pacific, I think that we must also realize that and be cognizant of the fact that Asia has got so many different parts of Asia, attitudes of people, what they're willing to do, and how they're doing things is also very, very different. Simon and Ken speak to Singapore. I think that there's a greater alignment of those matters there and the sort of attitudes there with that of Australia, but that may be terribly different from that in, let's say, Cambodia or Sri Lanka. I mean, Sri Lanka is a great example because they are experiencing issues which are very unique to their jurisdiction, which is not something that somebody who is affected by COVID supply chain restrictions or the cost of energy by the Ukraine war. So we are still very much dealing with horses for courses, very, very different types of disputes, very different types of attitudes. And, in some ways, it's a bit like what people speak to in terms of a two-speed economy. One thing I think is very, very clear, however, and this is a trend that I've been seeing much more, and I think is going to go forward with, is the role of the lawyers and the experts. The role of the lawyers and the experts starting early, starting to be engaged, not necessarily at the point of a dispute arising, but really right from the beginning. And the ability of lawyers and experts to actually guide their clients to see what is real and what is not so realistic, despite clients feeling very passionate about a particular stand that they're taking or a wrong that they feel has been imposed on them. I believe that actually this is happening now much more. Of course, I mean, take a horse to water, can't force them to drink it, that kind of adage still continues to operate. But understanding the various attitudes and how to get around it is something that my colleagues on this panel are able to assist greatly. And with that, I think, bring some closure to some of the disputes. And that's something that I've always advocated, and I hear this in everything that everybody is talking about, is the fact that you might not be able to solve everything, but if you can narrow down the disputes, obviously that's going to help with the cost, the time, the efficiency, and the general experience of dispute resolution. So technology obviously is going to be a big part of that, as John was talking about the fact that, doing things over Zoom or any other Epic or all these various platforms, there is a lot that has been done in that respect. I think that in terms of artificial intelligence nowadays, we have so much documentation, so much information that's electronic, the party that doesn't engage and use artificial intelligence and technology is obviously going to be at a disadvantage. I mean, you imagine thumbing through the physical documents as how I started my career in those days. I mean, that is, the young lawyers find that this is unheard of. And yet, those of my generation will not just remember thumbing through a lot of documents, but carrying physical documents and getting bad backs as a result of that. So I think that your trends that we're seeing are for the better, but there's still a lot that we can do to make it more streamlined in order to get to the end result that I speak to. We talked about early alignment of experts. I think that actually tribunals nowadays, particularly the so-called more modern ones who are more up to date with things, are more willing to be a little bit more robust and to actually get the experts together and actually hot tub them early on, not waiting until all the reports have been done and waiting to the actual oral hearing, but to actually try and get them aligned early. Because one of the things that we talked about, and I see as well, is the fact that when experts start on their work, quite often they're asking for additional documents. And quite often those additional documents have to be put into the arbitration as supplementary bundles because nobody actually thought that they were useful or that were needed. So these are sort of things that we tend to extend the whole process if we're not careful. One of the things that I think we are going to see a lot more of is a mismatch between the conditions of contract and the division of liability, allocation of liability, in light of world events that were probably not quite expected. We talked about shortages, we talked about supply chain disruptions, but we have also to take into account labor shortages. The fact that we're going more towards industrialized building systems and precast, as Simon was talking about, yeah, we've been talking about that for a long time, but it hasn't really happened in a big scale. There is still a huge dependence on cheap labor. Something like Brexit, plays into all of this. We also now are seeing increase in interest rates. We're seeing inflation. We're seeing a lot of difficulty in crossing borders for people. Now, all these issues, apart from COVID itself, which it's almost like a thing of the past, but the COVID issues remain with us. So is something a legislative change or is it not? And these are the sort of issues that are going to play into construction contract, the actual clauses itself. So the way I see it is that all these lawyers and experts out there are going to be looking around for very clever arguments to get around what's actually stated in the contract and how to deal with these issues and these disputes, which are very, very real, but for which liability is not very clearly allocated in the contract, and how we're going to deal with that kind of things going forward. The way I see it is that, as always, a lot of clever lawyers out there, we've got some in front of us here, who are going to be finding ways and arguments that can suit that particular purpose. But the experts are going to have to keep up with it. And because these may be innovative arguments, it is likely that the outcomes of those arguments may be patchy. You win some, you lose some. So where the experts are concerned, I think that there's a lot more of keeping up and trying to keep up now. Because if, for example, out of 10 events of delay, only 3 are allowed because of these clever arguments, then you now have to have your expert report able to cater for only dealing with, let's say, those 3 events that are allowed. So, this question of if yes, then what? If no, then what? Which brings me to one of the last things I'd like to say, which is that as tribunal and previously as counsel, I've seen decision-making flowcharts being used to absolutely great success. But that takes parties being on song, parties actually wanting to find that specific outcome and willing to work together to actually come up with that decision-making flowchart. Look, guys, at the end of the day, you don't want a tribunal like myself. I'm a trained lawyer. I may be very experienced in construction, but I'm no QS. I'm no delay expert. You don't want me to be making decisions that's outside your contemplation. So basically, you're trying to guide the tribunal to a very specific result. And it may be a specific dollar and cents. Is the tax to be added or not to be added? That may be one of the questions, and that in itself can influence exactly how much it is. So you don't want us to be doing the mathematics for you. So these are the sort of things I think that we need to be moving forward, and the use of technology and the use of, for example, the Zoom platform to be able to have much more engagement between parties, between experts, between the tribunal and the legal teams. These are all sort of things that we need to be doing much more. Dispute boards are fantastic. I sit on dispute boards as well. And again, a lot of times it's a question of what the attitudes are. I mean, to date, most of the dispute boards are on multilateral bank projects. They often involve government clients. And you might find that actually government clients, regardless of what they may think themselves, but do not they are fearful, shall I say, of putting forward a suggestion that is perhaps outside of the strict letter of the contract. So they may appear very conservative and may appear even obstructive at times. So how do you guys as lawyers and experts actually help to ameliorate that? Yeah, so coming back again, just to close off, I mean, where the trends are concerned, all that is being spoken of, yes, totally agree with you. I think for me, the question is that where do we go from here? We can talk about the past, we can talk about the present. What we really ought to be doing is using that knowledge, using that experience, and moving forward in a more efficient manner. Having said that, I understand 30 plus years, the fundamentals haven't changed. People are still fighting over the same few issues. So one can live in hope, one can be optimistic, and one can actually be a part of that change, and one can be part of that trend. So thank you very much for letting me ramble on.
Thanks, Swee. I really like that sentiment of, living in hope and being optimistic. You touched on a really interesting point about artificial intelligence and just the wealth and volume of data that is available, and I think especially from doing electronic document reviews. And I think that touches on a point that John made with regard to experts analysing data for the purposes of preparing their reports, looking at a period of time and activities and costs that happen within that period of time. The collection of that data is critical. So we've had a few questions come in on the chat. So the first question is, and this may be one for you, Swee, and also Simon and Ken. Does the construction arbitration system deal with post-completion forensic analysis of dangerous defects, or is this normally a matter for the court system?
Let me let the lawyers deal with it first before I jump in.
Happy to kick off if that's okay. I thought it was a great question, and obviously arbitration is a creature of contract, so it's about claims where there is a contract that provides for an arbitration clause, and generally then deals with commercial contract disputes. Arbitration is generally about liability for damages and generally about money claims, but there can be orders for specific performance and for injunctions. Arbitration can deal with matters of urgency, and that there is an ability to have emergency arbitrators appointed to deal with things that are critical. And sometimes there can be a preference in these sorts of circumstances for confidentiality. And I could see here there would be a commercial dispute and liability for defects, and there being monetary aspects to it. And in that way, it would be germane to an arbitration. However, if we're talking about an enforcement by a statutory body, a non-party under some legislation, then there would be no jurisdiction. And if we're also talking about something like criminal liability, that's clearly not commercial and would not be within the scope of the arbitration, and in those cases would be pursued by a statutory body or the government, and would be something that you would need to take to the courts. So I suppose it depends a little bit on the facts and also what aspects of the dispute. Even if you were to have enforcements by a stat body or under criminal legislation and some stuff in the courts, there would also be, I think, contractual implications for that, and that would be something that could be dealt with in arbitration. So that's my 2 cents worth on that.
I was only going to add there, Simon, that I saw when the question came in, I agree it's a good one. I wrote down arbitrability, what does the contract say, and the role of third parties and proportionate liability. So it's a pretty complex area, and particularly if you're dealing with something like safety. there's a real question as to sort of what the appropriate forum there is. So yeah, I agree with all of that.
Swee, did you have anything to add in relation to that question?
Yeah, I was going to say that Simon and Ken have hit the nail on the head, because if it comes before me as tribunal, I mean, my real issue here is jurisdiction. Do I or do I not have jurisdiction to deal with that issue? And as they have said, it's a contractual jurisdiction that I have, as opposed to courts or statutory bodies enforcing statutory rights and perhaps even penalties. But I'll use a real life example, which I skirted around, but didn't actually get involved in the end. And that was one of unexploded ordinances. It was a dredging contract, and they dredged up unexploded ordinances, and it was part of the fill. So what do you do then? Obviously that there is a contractual aspect of it, but there is a safety aspect of it, and there is a statutory aspect of it, which makes the whole thing kind of split up. And you may end up, as Simon said, dealing with the entire issue in various forums that is suitable for that specific area of dispute. So I'm afraid that there isn't quite a one-size-fits-all answer, other than to ensure that your tribunal has jurisdiction, because without that, you can forget it.
Yes, that jurisdiction issue is a very interesting one. Before we wrap up, I wanted to put a question to John. Swee, you said that it's really important that experts keep up with these evolving legal arguments that are being developed, and they might be quite creative arguments. And Simon mentioned when he was speaking that arbitration is sometimes criticised because there's not the publication of awards and there's no right of appeal. So, John, I just wanted to ask you, as an expert, how do you go about making sure you're keeping up with these evolving legal arguments, especially with all of the complexities that we're seeing in current construction disputes?
Well, yes, first of all, by being involved in webinars like this, I suppose. Yeah, obviously we do continuously undertake, courses and attend current webinars and seminars, etc. And as part of our, ongoing CPD, continuing professional development. So that's always one of the most important factors. And then I suppose learning through experience is always critical as well, just through the process of working on various expert reports and liaising with the legal team, etc. And in getting directions on your instructions and clarifying the direction for those, etc. So I suppose just through that process would be the main way that we would try and keep as up to date as possible.
Yes, and the role of webinars and ongoing CPD is so important, not only for the lawyers, but obviously the experts as well.
Yes.
Well, I think that's it on the question front. I'd just like to take this opportunity to thank our panelists today, to thank you, Simon, John, Swee, and Ken for joining us. And for everyone who participated, thank you. After the event, you will receive an email with a recording of the webinar and also a short survey to complete, just so we can get your feedback and ensure that our future webinars are of benefit and on topic for you. So thank you once again for joining. I hope you all enjoy the rest of your day, and I hope to see you all on our next webinar.
Great.
Cheers.
Thanks, Erica. Thank you.
Thanks, everybody.
Thank you.
Thank you all. Bye-bye.
Bye. Bye.